ebusu mo kwa ba the back channel high gossip Ghana TV pa cho ba ha dia like channel subscribe na turn on post notifications na be biazo nya fe enso eho enomo me nkodi nkomo na nda ye court na ekono eye ma me AKOSUA SERWAA so the sisi busapini or ex busapini Victor Kofi so ena ODO BRONI ena one other person ne munsem ne akopie court na akokodi nkomo enso eho no ye no ya be fe na AKOSUA kokrowa de nkomo no enso ebre na yesunya de ne atenwama se na bia uke bia betimi akabina me bia so fam such a de ma information educate na entertain o enso ede account nkodi nkomo no ho quickly na bia anya fam pa cho ba ha de like it channel subscribe na turn on notifications so na bia anso nya fe enso nkodi nkomo no bia anya fe enso no.
Judgment of the Age. Seek see on AKOSUA SERWAA versus Abuse of Pen and Kofi Ozu, ODO BRONI, and one other. Part 1.
Na me de hia me kese pa ne se wo beti asem na court ne kai na se na wanka se wasi gina ya ma wo ho na gwahu se mra no eye se ne etie na ye de to na nya se ne wo pese ye de to ene ye de to na judgment no anu nie eye 49 pages 49 page judgment 49 page judgment ena ene ye ba bedi ho komo se de maka ne ye be chichem nti make sure say wenya ni nyina abom ansana waka say me say ana say me say bomoden a case na ye de hyase no eye ya ye case a e fa ye living legend eye me living legend wososo we living legend a ene watoa nananom e wa samando a ye friend daddy LUMBA ne yire anama menka ne yire nom AKOSUA SERWAA ene ODO BRONI anase Priscilla Ofori asemo a wode kodan court say court emu ahwan na ye yire ye maami AKOSUA SERWAA ena de court ntini sent ye friend plaintiff anase de ode na asema bedan court no ye friend plaintiff na ode ko no ode ni German address ena to so e German address ena ode ye na obuti ya baako ode abusua panyin Kofi Usu ne otosu mienu Priscilla Ofori de nyina ye friend ODO BRONI no ena transitions home baby another the LUMBA womo se say ni funu no eda ho no me kasa womo se say me pa choice asem ni hu asem ana asem ni mu no kore tina me se womo se say enti no judgment Dr. Justice Dr. Dorinda Smith Arthur oya high court judge e wo Kumasi her ladyship me de me friend her ladyship esanse oye her ladyship emame into her ladyship Justice Dr. Dorinda Smith Arthur on February 28th 2025 November Friday 28th day of November 2025 now Osha see and say no kan we ye introduction into ha no ye be dealing with page 1 to page 5 for pe ye nkwa chiri kura na ye de to aso Pacho say we can do nothing against the truth but for the truth. Nyame na make am judge ne na twero e pa cho enne wase ho no. O say we can do nothing against the truth but for the truth. En okoti ye so we free 2 Corinthians 13:8 NKJ version and New King James version. Mo amun kan Bible no. E New King James version. O sha ase no see ni introduction ene say asem yi maami AKOSUA SERWAA ene de baaye na ode baaye say yenka se wono nko a ene yire a oware Charles Kwadwofosu aka Daddy LUMBA na ne sai mususu nti no wono nko a ene yire a wo sefata say wo bedi kuna ama ne ewawi eye Daddy LUMBA wo saso sre court ne say court no nsi abusua panyin kwan na emma ODO BRONI entimi emba di kuna anase won kan kire wo bi say oyeyere o worry Daddy LUMBA enti brofumu no say a spouse of the deceased and further ordering a restraining against Priscilla Ofori from carrying herself as a surviving spouse of the late Charles Kwadwofosu aka Daddy LUMBA. The plaintiff alleges that she na me patwa me san betwi mu kafra ame san family twi mu na ye maami AKOSUA SERWAA court or court na mane say wono nko a ene oba kunani a ya ware no ewo mrem ne ye ka se ordinance marriage and na say civil marriage registry ewo jama abonten so 2004 and that omo ware no until say oni lumba ebewu no na oni lumba omunja aware nti opese che say ekopem July 26 no oni lumba inja aware asem aye maame ode call down court no judgment na mususu no was my lady and I say her ladyship Justice Arthur etro say one more wode asem no beti a wo mo eya busua panyin transitions any ODO BRONI susu say na asem na wo ka no enye no kra in its entirety na chese ba bia ni ho a eye no kre na wo mu enyi ntumu say ya maame AKOSUA SERWAA ono nko a na ye yere na one Daddy LUMBA contracte ordinance marriage ewo Germany I hono moto fani de minim say ye nyina ye nim enti no ye ba pleadings a eye asem pa wo de koto court nanim no eno na mabobo bisu akere mu se no ye pay 2 no e pese me bo page number no na wo ne me ya no wahu se wo ne me na ye den eko nti e ba pay 2 pay 3 honom na wo bobo ne ma na wo pe eno a na me kan ye no se wo pese court ne ka se wo no nko a ne Daddy LUMBA yere owi a court no and declare say wo no nko asoso na wo ehu yakwanya say wo bedi kuna na owi asoso a court no emma enshem defendants no and as ODO BRONI ni okay we ha say no first defendant which is abusua panyin no court ni nhye abusua panyin ni say manu manen enka say ODO BRONI yeyere na onsi ODO BRONI so kwan say ono so enam say ono so yeyere enti na asem a ode kodan court ni nyina eno no na yesi ono ankasa no na no asem a ode court nyina no issue a rate nti owie ye no ni statement of claim e ka ho ni bibia ode bedan court na ye komu a ni ye court ni friend issues for determination no eno na be ye next video medase yo mesama wakwa babiem say yakasa issues for determination na che say edian asem ana say edian asem na aba e wo say court no ebua wo engina so mbu asem no na saa nsem no court no etimi e de 11 baako du baako na eda court nanim ni edikan asem we hu hia pa esan say issues no eno na judgment ni nyina owura ye na owura during the ata obegina so de ebu asem no enti e wose wutie ni pa se de be ya obehu asem bia ne de obeka afa ho asem bia ne de obegina so afa ho enti tie ni edi kan say whether or not the plaintiff is the only surviving spouse of the late Charles Kwadwofosu na ne kire say eye no kure say ye maame AKOSUA SERWAA wono nko a na eye yewura Daddy LUMBA ana say Charles Kwadwofosu oye ne yere eye no kure ana say enye no kure ne etosu mienu eye no kure ana say enye no kure say ye maame AKOSUA SERWAA wono pe na oye Daddy LUMBA yere a na che so ono nko na woso odi kuna ana eno ne asem a court no setting it down mienu no the next one is say whether or not the plaintiff make a plaintiff be anu say ye maame AKOSUA SERWAA san so na dey asem na kodan court we di kan chirechirem o me see first video na no akwa akohwe enti no whether say ono na say oni Daddy LUMBA ente for 17 years no e constitute abandonment na just abandonment say we jane hokokora me so say ni na yatetete ho nsem e wo media yi so a enti court no e de to ho na e ka ODO BRONI susu anu asem a ene defendants na anu asem o mo de baaye enti sa issues we e niema enipa mienu no anu asem we sise no enum e na ye yi sa issues we efri na chese ye de aba bebua asem no enti for anu so ne say whether or not the plaintiff causing her lawyers to write to Daddy LUMBA demanding her shares of the property omo mienu ne janya aye no ba bia yete say yese ya maame AKOSUA etro krata akoma nira Daddy LUMBA say wo mun charge apade ni no e kire say na aware na gu ana say constitute an intention to dissolve the marriage na say maame aye na adwo so beja aware na wo ye na adwo so beja aware na sunsun sanso now whether or not say the second defendant can be deemed as a wife on the basis of customary marriage say ODO BRONI obetimi aka so wo ye yere e wo efie anasa amamre awarem between the anko yamu fancha me misremo. Can it be said that the second defendant living with the late Daddy Lumba for 15 years and having 6 children with him constituted marriage? Not just say yebusa say obetimi aka say yay mame ODO BRONI oni ye papa Daddy Lumba tena ye no obetimi aka say ne senti no omu mienu atena 15 years aboro so omu relationship na say ade bia e wo omu ntam ne betimi aka say ya aware ana say nya aware omu sasu kura nkwada 6 court ne kan wa ha na yes court no so say busa say nanso Owura Charles Kojofosu wo ware no kuremu e wo German mmeremu ana say etisa ana say entisa eno na ye number 7 number 8 o say ye mama Akosua Serwaa was started divorce proceedings bitia Daddy Lumba na the etoso 9 whether or not say ye Owura Charles Kojofosu woni ye mama Akosua Serwaa etna ye e wa ware kwan so emra wo ba Ghana na sawote asie me pa chow the etoso edu no say ye Owura Charles Kojofosu watena Ghana ha 15 years no na chese say ne tena bia no e Ghana na say ye Germany court ni na ebisa nyame na mbisa no owie ye de etoso du ba ko no say na ware na ewo ono ne ye mama Akosua Serwaa ntamu no na egu ewo German mremu ansa na wo ba Ghana na de etwa tokora ne say asem bia ebepeja efrimu nti ye de we ka ho na chese issues no asset down nti afa die ye tibi ko trial ye nto aso
Part 3.
ya dru no ye ba be kan ye mama Akosua na no asem se ne ye wo judgment nim na no asem ne sen ye say o testify true ne attorney se mremu ne ye kasa attorney na chese ye mama Akosua wodi tumi ema maami bia e friend George na o say bonsu say ono embe gina na namu no onka na no asemoma no e wo court na chese o ma ne power of attorney nti ha no maami George na o say bonsu no obeye attorney e ma ye maami Akosua Serwaa nti ono na ma evidence in chief na chese ono na gina mudi adanse kese anasa adanse ye gina so maami Akosua Serwaa di gina so kan na asemu nyina no ono e na ebe maaye na o say adansi ya mama George na edi ma ya mama Akosua Serwaa ni wo say ya mama Akosua Serwaa ena ye emremu yire e ma Daddy Lumba na wo ware ni wo fie na wo saso ware na wo German mrem owie ye na wo saso to aso ka say omo ware wo German mrem 23 December 2004 e wo German mrem registry Bonham e wo Germany na before so omo ba be yes sa German na ware no kora no na oma baba ye fia ware wo bom so Ashanti region de dada enti awade ni mu no munya nkwada miensa awade no so anguda ekopem say Daddy Lumba ka ba bi 26 July 2025 osaso de ka ho say we ye said ye judge ni ti no ne judge no twero no eno na make a kyerɛw enye said ono kan nti okasa wankasa me de minim de okai ne judge no de ba ne judgment ya 49 page judgment no eno mu na make a kyerɛw now also the can who say o say she further stated mama kanisa no we who say judge na e can make me church the woman she further stated that the death of Daddy Lumba the head of family after the death of Daddy Lumba the head of the family which is defendant 1 yenina yenim na busua panyin informed the plaintiff that she would not be allowed to perform widowhood rights yatiti wa media yiso say ebusua panyin kacha Akosua Serwaa say wo ma no eni kuna ya maami George na bonsu o say bonsu wo okan wa ha o sa so kaka ho say ono eni ODO BRONI say ya maami Akosua Serwaa ware no egu na oja Daddy Lumba esimu ebro 10 years ni eno so enye no kre wo ka say ya maami Akosua Serwaa ba bia oba ni kunu ho wo si supi say 2011 2012 2014 any 2018 ambra ne maami wuye no nyina mu no wo baaye no okoni kunu ho osaso ka say ye papa Daddy Lumba ni di na ewo ye maami Akosua Serwaa maami eyie poster so say asew ai ebusua ne pene ye ema ne ye ensuwie ema ye maami Akosua Serwaa maami osaso de kan ho say ye maami Akosua Serwaa kra na oto eduro bere no na oto eduro ede bre no Enti entimi mba say na waja nesi baby na osaso so confirm say emra wodi ni 60th birthday no asem no a wokan ye no ekra kire say wanyi no ama na ya maami George na to aso ka say ya maami AKOSUA SERWAA na ono na ye LUMBA do na osaso kra bo nwum bebre ema no a sesi a wowu ye nyina ya titibi enti no ono nko a ene oba abusua no enimu no oto aso ka say omumienu she further said that D2 which is ODO BRONI carry ne ho to say yere simply because say oni ni kunu no e wo masex ebi wa na me de brofo na frame hu say de be ya nchiremu no bekoyi so what I say enti no okaka ho say enu nti e na odi siuti aba say de be ya wonka sa asem ni biem enti a copy of the rates no any statement of claim ni nyina no ye gi tumu as evidence enti sesia no enu nti na war court say court en restraining ODO BRONI said the be ya wonka say or ye legally married woman na waba be perform widowhood rights no said ye mra e kire no enti won ma ono nko a AKOSUA SERWAA e na enye osaso ka say e papa daddy LUMBA ne brand na iconic enti no ya maami AKOSUA SERWAA wanya na agyen say ode na wari asem ebetu bedwam enu nti na nkrofo ka say ade nti na wo wuye ene wo ka na asem a eye saa ene ema ntia enti say wo ye na agyen say wo be na ntia free aware enim na enye say odo eni omuntem na osaso kra choro ka say emra wo ye na agyen say krata na wo mo ka na emra wo ye na agyen so pese wo free aware enim no e papa daddy LUMBA sre no e pa na cho wo odo mu no no so wo odo mu no te ase e na otena ye enti no ama na amfa etrin san na nko de kwakoma daddy LUMBA abusuafo no wanfa nko enti na ware no enguye ochocho na no nsem no bebre enti ni nyina se de tete wo media ni metwitwa so nya se be wo bebre ye ntimi enka asem ne be edi ehia no pa enti ye jampia na ya ba page 9 so nipa the friend defendant's case page 9 na when the defendant's case no wo enti ODO BRONI asem wo ho ebusua panyin so asem wo ho page 9 echo 12 ODO BRONI asem wo ho ebusua panyin asem wo ho se de yatete wo media ni mu na nyina e wa ha na yemra
Part 4.
yet waswa ye ko page 15 straight ye ko page 15 straight na page 15 no ehwa na ya cho evaluation of evidence finding of fact any application of the law Mera anase her ladyship Dorinda Arthur say hano oba be evaluate nkrata anase adanse a wo de baaye ene nsem wo be kekaaye na owie a wo de mbra no atoto ho nti no say ansakra na wo be yesa no wo be ko issues na okay issues na mekaaye no 11 issues na mekaaye no o si ansa na wo be ko ho no mo no o pese o discuss nia embra no kire say wona wo be kaaye nti wona wo se wo kire say ye no kore anaye say nye no kore the ebrenum from the burden of proof nti o say I wish to discuss the burden of proof on each of the parties no shase o say ye embra say wa wo de wasem ababedan court no wo ena wo sa burden of proof no enti wo na wo say wo na wo se wo kire say ne a wo say no sa na tie ti wo na wo se wo de adanse a kire say wasem a wo ka no eye no kre no wo na e wo se wo de ba na asem no so a wo krata wo de ba no so e wo say ye krata e fe no admissible so wona kese nya asem bia e na wo de court a ana secretary bia na de court timi gitum ebi enya admissible ebi ya admissible nti ha say no say it is a basic principle of law of evidence that a plaintiff in a civil case has the legal and evidential burden to produce admissible evidence to prove his or her claim and assertions on the preponderance of probabilities. Nehono state section 11(4), section 12(1), and section 14 of the Evidence Act, NRCD 323. State ka ho. Obi e no say, sa emra we kire say, sa emra we Supreme Court kura etiem and as I can say Supreme Court a team so we team so the case of Ejubin versus Domfe 1996 to 1997 page 660 as Supreme Court say wa crystallizing the standard of proof was civil cases in name say wo na ade asem no ba ya wo na wo say wo be kire asem no say ye nokre ana say ye nokre osan so bo cases bi esoso ni nyina a wo de kire say wo na wo say wo de wadanse e ba be dan court ana say obi a wo de na asem e ba court no wo na wo say wo ho adanse a e be kire say wo asem no edimu ana say endimu we na wo de share ni evaluation no ase na owie ye no wo baaye in fact obobo cases bebree so cases no edoso e ka te bebo bo ni nyina mu a obobo cases ne so na cases no pa na de edimu ntentene pa baako eye Aka versus Pega Transport na Zamrama versus Sebeji na Gihok Refrigeration na Household Products versus Hana Isa Asi enti no se si anopese o kire say burden of proof no a e be kire say wasem wo mu ana ase ni mu no ejina plentiful no so ya asem ya ye kan mu plentiful no ye maame AKOSUA SERWAA nti wono ne so na gina say na asem wo de ba ye na wo mu ana ase enim esan say wo na wo so wo ye court ne de otene ba bi na wo de wasem aba nti wo say wo be kire ye say ampa no kore mu wo ye yere se de wo ka no ewo German mmerem saa na we nyina no page no e ba besi yi nyina no ye maame eka enti said they make no bobo cases no so a na owie ye no en wo say e wo say meka asem na I must state to say or say I must state that said the be men kan asem nhye mewura ye my ladyship and anunity no meka na asem no na mewura ma kire mu or say I must state that some of the issues will be determined together e wo say because ensem bi won ma mebu o mabom esan say wo mo eye intertwined omo ye intertwined na say omo hia wo ba bi ntimebu abom na also no I will not or say they will also not be in order as listed during the direction stage e bia na webu abi ajabi wonye ne said pepepe said on hihye ne said wo hihye wo direction stage no direction stage be bia modem mo evidence ni mo ayi nyina akokọ kire court eni bibia no aha nti e bia na enye ne sa nti ni first issue a ofaye eni say ya maame AKOSUA SERWAA oye yire ana so wonye yire woye yire a wono nko ana ye yire ana say wonye wono nko ana ye yire na asem edi kan a wo faaye no share the next part.
Part 5.
So bakaya asem a yedru so a na ye maame Dorinda wo busa ne say o see the first issue a obe determine any say ya maame AKOSUA SERWAA ono nko any Daddy Lumba yire the only surviving spouse enti wono nko ana say enye ono nko eno ni asem edi kan a ye maame Dorinda edi kan ana say yewura Dorinda odi kan ebuaye o say same way na efata say ye maame AKOSUA SERWAA woli the evidence ana say wo kire court say ema court akoma to ne yem satisfaction say ono nko na eware say oware Daddy Lumba eno ye baako na aware na oware no na enya aware ya yeware bi ka ho na tese nya fi aware na emre no soso another Daddy Lumba ba be ewu ye no soso no na sa time na ware ni ngu ye sa ne ma we na e wo say wo kire court nti baako ene say wo kire court say wo ware Daddy Lumba mienu ene say wo be kire court say aware na no ne Daddy Lumba wo mo ntamu no na enye polygamous marriage na tese nya fi aware a utimi ware bi ka ho na emu me ye court aware na etoso miensa say aware no na engu ye na emu no omoda so ware ansana wo Daddy Lumba ba be free mu sa ne ma me ensen ena na ye ne wura wo hwe anim say anka e ma me AKOSUA SERWAA ene na lawyer for ebetimi akire court no na osaso ka say she is also required say obe prove sufficient tie brofo no ye tro law brofo are different enti word no words no e wasa woman wani ko ho was sufficient properly authentic documents which are not contradictory and legally valid in Ghana. Enti what? Enti no was start here. I was say sufficient. I say what say soon? What say no so? And soon what say no so? I say what to me? What say the better sini? Eh, authentic. As I say, authentic ni tree bed. Me just authentic. The yenye na ye kanti be hu ni tree. ena ento Ghana mbra enye different so from the Ghana yen mbra na yenimu no enye different saa na emen ena wo kafa a ye ma me akosua se wa evidence wo so wo de ba na saa na ma miensan ya wo kan yi obetimi dia establish e wo nasem nti oye no se here aha say the ono de ono wote ne court o aha no nti de mo de ba court no ho asem no beka nti o see here the plaintiff testified through judge no say bonsu say mo kai say me boni din ni attorney na me kan here no aha oso ono no na ono na ebegine na namu e kan na asem ma no osan so de a power of attorney no ebe kire ye no ne ma ni tumi ma ni begina na namu no owie ye no o see which was objected to by counsel for defendant counsel na anje antum na emomu no all the concerns with the dates of signature ne ne ma ni nyina no any time omu notarize ye no na document no ehu won sensem kakra enti no but later no it was not the case enti no ono de no kra no obogu ye je ni tumu ma me ne ye den etimi ebegina na nemu enti no owie no to aso beka say ODO BRONI lawyer so raise issue with signature no any ehun sensem nyina na passport any sensem bi but ono see of the view say significantly no omo ye different you know signatures ni ye different na me say honom ne de wa yi mewura anya ntum oso wo mumienu ne nsem ni nyina enti wo pene ma ye maame George na o say ebunsu edi adanse no e ma no enti counsel for ye maame Akosua Serwaa lawyer no or ne written submission mono or rely on Florini, Luca and another versus Mr. Samir and others. The honor no see it was to the plain purpose say the presence of a witness when it comes to the power of attorney is to attest to the instrument. Is to attest the instrument. He argues that the vital question the court should address its mind to is whether or not the plaintiff executed the instrument in the presence of the witness. Not just say, I am passing the power of attorney in man and I say one farmer no the man so na witness no ewo hono wa consider ni nyina e no say wa accept power of attorney say the medical aka no wo gi tu mu anu nti na ehun say ye maame no e na ye den e bedi adanse ye man no. Into say before I proceed to the evidence of the plaintiff maame nka o see answer no beko ye maame Akosua Serwaa evidence ne so no on ka say on ka major topics be already no wedi kan ka say asemi ama public interest also enti no abema news se wo ho dawson enti sa reason we enti na judgment no o siki so de be resolve disputes ni nyina se de be ya or de sa opportunity e be educate na wa enlighten the general public on certain sensitive matters enti wan judgment make ke wo kan judgment ni ya woto ne papa woto ne bo no twroye woto ne 49 pages enye easy woto ne bo no twroye o shall see the types of marriages in Ghana hono na me pese wo utie pa
Part 6.
Sama wakwa bebiem ansa na meto aso no ma menka asem we mesramu obi ambo me pa obi anhye me kutupa obi antua me ka se me membe chichirim me ya na mete wa na me se we eya adesua enti ye nyina ye nsuasua ne yefentu ye hofo se de be ya enkofa asem foforo madachi enti mesramu obi antua me ka obi ambo me pa wate me ya na eja konkonsa ye me de na me se mu me ndi kakra na we de konkonsa we yefentua de enti me pamacho utie na sopem ene konkonsem so as no wasua ade eso afrim medase enti ye do types of marriage baby a ye ne ra Dorinda Arthur esi ye no na osi wo be church types into or types of marriage in Ghana wo sheda eto nebo church types of marriage no eno nko ahu pages na edo so pa enti ye ho ne ye de hyase osi e wo Ghana mramu no anase e wo Ghana ha no ye wo aware miensa main and I say 3 main types of our real krom ha. Ni edikan customary marriage ye nyina efre ne fia aware no. Ni eto so court aware and I say ordinance. And na de etwa so Islamic marriage. No ka say aware dodo yi nyina na aware miensa yi nyina e bia kwan a efa so a ye bu no wombra mu say ye valid and I say edimu wasi ase enti no se wo fa ordinance marriage aye woni ema e kire se edimu se wo fa efia ware so aye woni ema e kire se edimu nti sa ware miensen omu nyina woni ema e kire de ye fa no validity any legality e wo krom ha se no now start free efia ware so say efia ware no it is celebrated under custom not just no e ye fie ye na mamre ene ye na mane kwan so e na eno no ebusuakuo bia na say me fa ne say ebusuakuo bia na say tribe bia wo kwan ya omofa so eye saa aware no enti enye pe wo baabi a e bia se ne ye ware e woda goma fom na e different se de si ware wasante fom se de ye ware ofafra fom ne be different for e bia se de ye ware woda gati fom so what I say enti no pe o kire se e different na emomu no it is mostly based on consent na chese nipa mienu no e wo so omunya omo ho ntiase em na abusua mienu no so nya omo ho ntiase na omo atimi aka saa oba ne be me ya bom se awarefo no wie no se ye fi aware wo Ghana no e wo se wutua tirinsa Emma ebusua panyi anase oba na busua na omusu agitum na omubọ machiri dom say aware no omugitum ye betimi a register fi aware wonim sa ha menim se wonim entusua wa ha wo betimi a register fi aware na emum ma menkam ento aso say wo register fi aware no ye ma wo certificate na emum ye tro wudin wo be kwakotro e wo registrar of courts registrar a owo assembly no ni register mu e ho na abekwa akotro ewu but eno ye ma certificate nti fi aware ye register pa okan wa ha na osaso ka se sa aware no e polygamous se wo ware obi ofie otimi ware obi ka ho e fi aware no ye nyina ye nim se ya ye wo ho ade ofie otimi ye oba foforo ho ade e ka wo ho me se oba foforo man ka be ma foforo ho ade It's no be ma ware ofie no otimi ware oba foforo ye den e ka wo ho or say there is no limit not just otimi ware ma bebre e de ka wo ho na no state the case of Graham versus Graham in person the legality no ebe bo mu bebre nti na ya me person but on my case or the support is na ya session and answer na asem no ehu no wie no be kan ordinance marriage aye court aware or say court aware na ye mra aware eye baako be ma baako ne oba de friend monogamous or be ma baako oba baako aware na sa so ye civil union e wo say emra mu no register na che say untimi nya court aware abra won register you so ka say waware wo court mu na won register ya enimu sa nti no e wo say register na parties ni mienu na wo mu ware no e wo say wo mienu nyina wo bi atintim so ne ya wo mu wi a ne ya edimu na e be kire se ma ware no ya mamu marriage certificate a e che say ma ware na sa ware ne de ya strictly monogamous na che say no ye ware bi nka ho be ma ni ntimi ware oba ne bi enka oba na wadi ka de na court ne ho sa na mewra dorinda ka wa ha nti wo cheche ma ware na ahodro ni mu se de be ya wo beti ase na wo ka asem a ehu ba bia be ka afa ti obi no sa se request se require se wo be ye formal registration wo district and our assembly to so kwa ye asori dem wedding and as court are say bra be register wo assembly bra be register wo ha no eno ho asem na o ka wa ha no o cheche we nyina mu na no so wie ye no na o ka se once aware converted that is if you aware o convert no ba ordinance ti waware ofie na okoye court dia automatically extinguish fie die no nti echese e muntimi be kasa maye ne ho ade ofie nti ne metimi aware bia ka ho abra wakwakoye court aware ye nya ne saa pacho wati ase nti enkoye obi ho ade na enkasa waye ne ho ade akoye wedding wasa akwakware bufufuro yes oni mra benya problem that's it. Into say we yes extinguish all your rights any privileges are over under customary marriage. Very simple. Normal Ekoma versus Shang. A very interesting case. I win that here. Sheshe Google ne read FF case ne. No, we are not say the last one here Islamic marriage. Ayen krema wari. Hence Islamic marriage ne there. Or say officiated by an Islamic religious leader and also so a potentially polygamous. Not as I know suit me worry ebika home. Now both the couples must be Muslims. Emremu no awose omu mienu nyina ye nkramofo no watimi a contracting nkramofo aware na mu wie so I was the registrar of Mohammedan marriages any divorce no awose mu notify no so ye register nti awose mu notify sa registrar no no so within a week or some mu ware ye no said e be ya ono so obe recording na ono so etimi atro mu din e won nkrata mu se mu mienu no mu aware e won nkramokwan so na mu wie so a awose sa aware no e officiated by an imam a sheikh or a kadi Sanko for me and say officiate our warrior no my warrior enim. And I also so see a man is able is allowed to marry up to 4 wives and it should not be between family relations and cousins. In my warrior no asichere no so wachere. O we no say e was a make kan say emra court no e one mandate say wetimi gu warrior in e wo court warrior mu no under the Matrimonial Causes Act 367 no. When it pertains to customary marriage, the court is enjoined to consider customary rules. In so person just say if you are warrior, it was a court no ehwe efie mmra no na ohwe nipa kro no personal laws uni so obi a won personal law obi a won personal law uni so personal law obi a won personal law dakro ebe chire mu obi a won personal law meti ha me won personal law so wo personal law nti ye hwe wo mamre ekwan so afa so ware ni ahwe personal law ni aka brom na ye de agina so abua se wo de efie aware ye kokoto ye ka nyinu ni bom ye de abua ne da se.
Part 7.
So for mama yen twaso ye wo page 22 na page 22 ho no na Yenera Dorinda Arthur Okasafa approving a valid marriage and say wo kire say waware edim anase waware e wo mremu no edim na ho no no start o say the primary and direct proof of a valid ordinance marriage is the performance of the marriage. That say ansa na wa betimi a che say waware edim no na e wo say aware no kra abaso say de ehun say bia wa ya yefro what na say no and the first one na wo wi a was a wunya documents a back case performance no enti anya se wa hihye nkonwa wa frɛ ya ba ma kyerɛ ma sensan bibi na ye hu krata bia na no kyerɛ se wa ware enti was a combination of other documents corroborating the performance of the marriage is more convincing than a single document. So as I say akofa wedding invitation ba nti okrata ne was a hunya so wie na oba beka say ye wo eniema bia enye it may not be enough to prove marriage. Example, or say ye wo emre bia marriage certificate nko a entimi nkyere say aware dimu ana say ndim eniema na bia marriage certificate nko a entimi nkyere say aware dimu no ene obubo obi any non consummation say nipa mienu makoye court aware na emu mienu munhia won namuda munhia won namuda ye hia maware so ma mu wie munhia won namuda eno ekyesa maware enim or see in fact or see and nullify not just our no kure ni ho na nkapesa abedimu ana endim and nullify no completely no see mental incapacity of a spouse e bia na wo ware no na nipa kro na adwen no ho enhyeda anya okay kakra and no so that is nipa kro no need the menstrual betimi a consent say aware no wo pene so ana wo pene so ntia no so e ma aware no enye dey enim e bi also see cases of fraud and na e bi so issues with certificates na nkasa or see e bi also aware no kra no efiri ahyase na chese egu ahyase na enim void ab issue na tesa aware na hyase na aware no enya aware papa na say egumpo abraham hyase nti mukora na mukonsumate kra aware na enya papa eno no work ye no say ebi ho no ma na wadi kan aware obi foforo e wo mmerem na say akoware obi e foforo so a sa aware na wo ware second one no enim ena fraud sa wo koye bia mi ti he na midin na e bia midin dia so mesi na makwa ka ni pakwa ne se midin dia obenti na mede no akwa ya ware no a eno no sa ware ni me sanse midin kura anya no kore e be dan ware na yeden awo enti wo kan no wie no refer to section 46 of cap 127 the Marriages Act 1884 to 1985 no or refer to no say sa so ena say wo convert wo fia ware o convert wo fia ware eko ordinance mu a wontimi ware obi foforo nka wo kai se meka wo ba ko ni sa o sa ka wo ha no say aside the say wo munhia wo namu da na niema we mosusu betimi ama aware no enimu kura na say be ye null annulled na tesa annulled na tesa aware na amaso abaso de na emu menimu wo mrem nti no ye begu no ene say enipa menu no mo ware ni nyina ye mofra Ghana ha yakaso bi abofra just wedi below 18 hence no sa nkura ware enim ana say parties ne ba akwa ware deda eno wo sa bebe ware obi ordinance marriage we nyefia ware wan hwe ba akọ na akọhwe me cheche mu ho spouse ne ba akọ ye force na chese nya ne pe no de ba ware enim o mo che ne kente no de o de ba ware enim ena evidence of deceit and fraud no so maka ho asem wo wie ye no ena oba say ebia na oba ne so say oba ne so nyemma be ma fofora sa ware no endim na instance anuanu mienu amo ware no so what's list na nye exhaustive betimi akeka nyemma bebre na with any of the above conditions or say when any of the above conditions prevail the marriage certificate alone na say sa nyemma we nyina e wo ho no mo a marriage certificate ne nko a entimi ma ware ni ndim. So the fact that we marriage certificate na sasa na ma we mo bia wo mu a aware na ntimi ndim emfa ho na certificate ayede e kura wo wie no honom no stay o ma no bibia atwa no de yabo so amam o ma mo a decided case and Estina Boatin versus Felix Serwaa and two others a call civil appeal and 2021 ya enche ntu hwehwe a wo be hu nti o wie ye no oba na say afede wo sa ba asem na o say I now return to the first issue a wo busa say Mami AKOSUA SERWAA na ware no o ware that LUMBA no say o ware no e was civil registry wo Germany na ware na monogamous na tese e baako oba baako be ma baako aware na say baba ko be ma baako aware aware no mugu no anaso omo ngu no ansa na that LUMBA nti owie na ho na obehya ase no say aha say plaintiff so kai plaintiff no wan kai akono kohwe mami AKOSUA SERWAA the plaintiff is required was a plaintiff no what chere o kai say make sufficient make ka brofo na make ka say sa brofo no twotwo ni nyina no mmara mu brofo nti enjoy mu sufficient say biane no so sufficient we say sufficient mmara mu aha sufficient properly authentic documents which are not contradictory and legally valid in Ghana as proof of a civil marriage to the late Dadu LUMBA sa brofo no ma chire kono kohwe. So I say this is very crucial. I say adewe and when here pa into what try I say this is very crucial. Wow. But there was a winner judgment if you could be 23 e honere. I say this is very crucial. It's an say I warrior back pe and I warrior won't mean warrior being count and only monogamous marriage and I say ordinance marriage and no warrior won't mean warrior being encounter. Oh yes I pe what tomorrow. Into a sister adewe the adikronti okase ye crucial is sense say mami AKOSUA SERWAA say oni that the LUMBA ware under ordinance and a civil marriage e wo Germany it was say crucial say ye be hu sankrata semi e wa semi a ye ba be buaye mu so we no say the lawful attorney some nyam kai de akere mo the lawful attorney o akere mo the lawful attorney ya mami gina ni obe gina mu di adanse ya mami AKOSUA SERWAA ha wono o say wo kasa no and as in some try what they buy the paragraph 5, 6, and 12 no oka say na ya mami AKOSUA SERWAA any that LUMBA omo ware 23rd day of December 2004 e wo Germany mrem na odsa so de ho krata e buy no wie ye no oka say ya mami so AKOSUA SERWAA kan when statement of claim paragraph 2 and also kasa. So see the first point I no person was ascertaining the determination of the applicable foreign law. E was same way nyina mu no. E evidence a plaintiff ne de ba say na wade no omo je e wo Germany and I say omo e contracted under the German law. Nti ho no state section 1 of the evidence act. Okay, evidence act. Me bo chere mu Ghana evidence act 323. State who provides as follows said the determination the determination of the law of an organization of states to the extent that such law is not part of the law of Ghana. Yeah, right. And that is say emra any Ghana mremono mama to fama emra any Ghana mremono or of the law of a foreign country aye o manfo froso mbra no aye o manfo froso mbra no a question of fact that is say asem a question of fact. It's a question of fact. But it shall be determined by courts. Asem a wo ho na mum court ne bebua say it sa na say ente sa. Into we no sa so say the determination 3 no say 1 no 1 2 ne kan into 1 3 of act 323 no e ho an that's which name. So say the determination whether a party has met the burden of providing evidence on a particular issue is a question of law to be determined by the court. Inti say wetimi I show where one krata asem ama na dimu no eye mrasem enye me say yes eye mrasem inti no so na a question of law a court no na betimi determine and so betimi abua e wo mrem me that's
Part 8.
It was okay say ye ka evidence act no and it was free ho into we no say e wo court e wo kuro bia so anase wo man bia so no ya assume say court bia nim ne man so mra ya make out say into court bia onim ne mra so mra into ne man ne Ghana onim Ghana man mra into no obetimi apply ne local law anase ne man mra na the foreign law ni dey operate as a question of fact and not as a law. So what I say, into umra now de ba no e fact mame enya mra mame enti no o de ba me de say de mebu asem mebu an o me Ghana mrem. So what I say, it was so my case into we no say this is to state that a foreign law must be proven by the party usually through an expert witness. No and when ya me pa I was here to see yes and say nsem na wo ka bebre no sansem wo kan wa he e ya sem hia o say so wo de mra a e free o man foforo so e ba e wo say wo a wo de sa mra no ba wo kire court nim na kwan be na be fa so kire court nim ye be expert witness ni obi a onim asem na ye ka no onim mu anasa wote ase no wo mu nyinaye o bi o mu certificate o mu nkrata e chese asemi ameka ho asemi e fa ne se meka pencil yi wasema wo se me hu pencil ye na me hu se pencil ye ni se so ase nti expert witness obi a woni made na expert ye ka expert ase wote ase nti expert na witness e na yaka bo mu aye na mera word expert witness nti no sa expert witness no e wo so no e be kasa e fa sa ade no ho. It must be proven through an expert witness, and a judge is not expected to automatically take judicial notice. You can judicial notice, and that is a be a judge in Wonim. You can say be a judge in Wonim. Say, John Mahama, ye man penny, a wagana, a judicial notice, yena, yenimunti judge, and is a bit me a judge to Musuni. Then, means me, can't judge say a foreign law, a judicial notice, and was saying also wedding, whom the Santino. What's with the expert witness, Eba, Nasa witness, no, or Becca Safa, seven home. Now, Krata, now, Debano. Judge need to meet us here. I was some brand no to me a day, a buasem no, a one a quine so. Into we no sin a sense, no, was here, my Yakusia say one. What should I say? One only that the lumba, or more no cremu, a one bremu or Germany. Emma, Intina was what far expert witness, so a children as I did. In the expert witness, or my example said it could have been a qualified legal practitioner, and I say academician will be a child about German or warrior. Ewo so ebia tis o ebetimi ayobia an expert witness can be anybody or kasa wa say owie no ka say or stated the case of Godka Group versus PS International and also a Ghana case 1999 to 2000 also the general principle has been that no person is a competent witness unless he is a practicing lawyer in the particular legal system in question, or unless he occupies a position or follows a calling in which he must necessarily acquire a practical working knowledge of the foreign law. And then I'm the church and say, what's any panel or senior or become once and say, and I say, yeah, dear, what dear Juma. And into now, I am running to know, or more as a lawyer, and he said, lawyer need ye, a dear, dear Juma, dear Emra. It is a lawyer needing the German Raya Juma, bet me a church German room. Into Quilbisano, okay. It is also required that a foreign law must be proved afresh. And you know, young fan say, I say, yeah, bay, say, yet me church German in Meremu ya. And no interest say, oh, soon as someone as I church the Muna now be general so debut. Over say, proving beam. It's say, it's Mrs. Ghana, Emeretrum, woman is Emeretrum. Into the same Emeretrum on my year. I just a one hour court number through your expert witness, say Merano, a trim. The Honor was stated the case of Amasewa versus Gariba, Hashmill. What guys are saying we? No, Munkai. Same way until 2021. A channel hopper. No, a Honor Justice Kulendi, or can't say. A Honor Justice Kulendi, refer to Section 136 of the Evidence Act. Evidence Act, there was a CCR by the Mohu 323 no on authentication. Honor say where the relevancy of evidence depends upon its authenticity or identity, so that authentication or identification is required as a condition precedent to admission. Inti sa okrata na wode ba no eye ni say enye authentica or say authentication and as identity no eye prerequisite and as precondition say e be authentic enye sa aye nyintumu a ehu hia say wo eye requirement say wo be satisfy evidence no by showing say it is supported what you say and I say edim. It is something, it's a matter of question. I was say we are normal court and transfer court ni be ya no amount. E ho no sa na omo e kire e wa ha. Into we justice Kulendi in the car in the case of Godka into my lady refer to no we no sa buy no say ha say no the purported extracts omo di free marriage registry ni mo buy no a foreign document a bear foreign signature. Now, the Evidence Act, this is specifically I provide say a condition precedent for the admission. And I came out to see and said Justice Kulendi can. It was Section 136 of Evidence Act anymore. Or see, it's a condition precedent. Not just say a idea I was a way ya. Not just say what to watch in a so as I say, for admission into 1 year, 1 year. Into what's a prove this idea way. Section 136, Section 161. So session say can na wo kambo mu a eno kire ne senti kura wo say wo prove visa akrata na wo di free on my foforo so ba no na sa so no ka say exhibit B no na e wo say eye authenticated and a certificate of marriage na free registrar of the civil office hoba ye no so na e wo say no so e bear some authentication after that no say the law mandates that a person takes the certificate e wo say ni panel certificate no e kwa German embassy Ghana embassy wa German Emma almost another certification from the head of consulate wo hono before a court no ebetimi ayede ebua asem no that's na okasa no so no o say eye ODO BRONI lawyer say munna munim D2 say ade munim D2 ye ODO BRONI lawyer so omo peda akrata no so no wo ma asem so o say there be menti ase esan say sa asemi abapen na krata yi emre bi a wo mo koma injunction so mo ka injunction no mo file in October no mo kai injunction no mo ma so October no 28 October 2025 no sakrata akro ya o judge na ka wa ha o se sakrata akro ya ene ye dia aba abra ye tie substantive case no injunction ni mo e baaye injunction ni mo krata ya mo de baaye e ba so say asem na mo ka no na krata na mo de aba no endimu enti se mo pese mo de ba ha de a wonim de wo beye me what I say o se me kire ne say safa kone koye ne ai wo se wo de ye ansa na wasa de aba enti ye me nwanwa o kan wo se nya na me ka wo re wo betimi aka ya ka me mpegya nkire wo betimi aka ya na me mpegya nkire ye ade no o se wo de ma me kan nkire but it is therefore a surprise that the plaintiff did not comply with the requirements nearly a month later. Na me ka wo se enti ye ne nwanwa say edi busu me atwam na plaintiff no wanya nwere kwasa de krata na yeden abre ne sa ne senti no o se kwasa de abre ne sei yede ento aso enti no omo pagya sa krata ne so omo de ba be evidence e ho no na ODO BRONI lawyer no D2 lawyer so mo ne medical check mo D2 o pagya asem ne se da bi menti ase e makrata we yenya de yenyi nto me san se krata we ye 130 KT ye signature na ewo so no enye ye man mu ha official e signature na ewo so obia so so ntwero krata amfiri ba bi mba mbeka say we etisei expert witness bia so so mbeka san fa sa krata yi hu ne senti me da so gina ne mi gina say krata we entimi anyi ntum wa ha ye ntimi anyi ntum e wa ha enti no me mpere ma court anyi ntum na hono na court ne kwakwa bo so secretary ya ba pen amahu asem ayeden aba ma no kra nti ono kra ne wanwan secretary ya sa aba ne ha ya anya ho hwe ya sa de aba nti ne hono no ka say ti any objection a omo pagya e wo secretary yi ho it shall be or say any e krata no it shall be admitted into what the objection ni to or the ODO BRONI lawyer no objection ni to say krata no and exhibit B and B1 no ye purported marriage certificate no mo translate enti omo translate ye e ba brofo kasem se de be judge ni betimi aka enti na nkofo kasem na judge ne tiase na judge ne tiase o translate and authenticate ye translation ni authentication they are two different things in translation said they make country ni brofo me dane no me translate na say we be authenticated there is to give validity no validity is to give validity to krata so what I say nti osano na judge no wo person worker nti wo ye no say nti me I nti o say then also purported the original that was brought before by the court for the court to compare the plaintiff to said the omode ba ye no say court no nya de nsusu ho nti no ni chese ni nsam keka ni nyina ni say han wo fa ni say certificate na ba na foreign document I be foreign signature nse hono mo na maka nti ni say nti no ka wo so ono de court ne kan wa ha wo say nti nke wo so wo mu frɛ obi wo so wo mu frɛ obi ma ne be kasa fa ho to hu se wo ka asem na se nke wo so wo mu frɛ obi e ma ne be kan wo so wo mu be frɛ e hono no ye be kasa bi wo ho about discretion nkofa can be about discretion the next way no ye be kasa bi about discretion we'll talk about it until even though the court is not bound until impose the expert witness by no just all the expert witness by ya assembly expert witness no e be can be na court na dia tum there be nya sanity na mum no expert witness no will be as persuasive as possible however the court na and expert witness asem na ntum a e was a court no try the grunti a wanje expert witness na anya dey asem wan to ha so ye hu expert witness bia anya dey amba nti no waji tum nti owie no osabeka say these required provisions were not adhered to by the plaintiff. I was section 161, section 136. Nia ya keken nyina. E ma me AKOSUA SERWAA omo andi so. omo endi so e wo mremu mesrew mrem omo endi so nti no se they were not ahead to na wasaso so kati mu say the page 18 of the written address by Mami AKOSUA SERWAA lawyer no. The council did not only admit what you to say or my authenticated documents no. Lawyer na nkasa di to say or my authenticated documents after injunction in October. Lawyer na asa di to ha say or my authenticated document name modern church mu ka ho say na emu edin na edin ma no so mo beye esan say na emre ne niam kakento say it was practically I say that are practical hardship. That is what stress and your bay na name more demand say or more be meet the demands no of section 161 no and was in name no or more trust was in name was and yet in answer to interrogatories near questions be a would answer and sana just say you started trial and say baby jira kemu ni ebu asem ni busa wa no yi asem na no na ha ti sa interrogatories na sa questions na court no omu yi ano no do boni sorry AKOSUA SERWAA omu yi ano answer no omu dey ban. I say the first question was answered to show say the document na omu dey ban your authentic marriage certificate. See the first answer no was it was answered to show say it was an authentic marriage certificate. The Counselor of Ghana Mission with Germany attach me wa na ntesa o ha o nyam na make so nyam na make or say which was not the case. No so say this interrogatory nti ho no ka clerk na sem no ka ba mo say de mo te wa happy so nti ho no de ntwa so nti o say sim ho ni nyina ho nsem ni na me pese but sansem no wo ho hana clerk na sem no page 27 year dream hana clerk na sem ni nyina ye de ewo nti no sa ho de nyina TDC ye. So say it must state that there is a distinction between the legal burden of proof and evidential burden of proof. Me catch am say marane de enye say ne open no na say ne marane tem sa to say legal burden of proof ni evidential burden of proof. No say when it comes to the legal burden of proof, anyone who makes an assertion bore the burden into say about legal burden of proof. I say when I will say okay some maka so when I will say when I was so chire ni o mu say you 2 million na chire si na mabube no enti no sa na ha no ye pese ye chire sa na ha ne ye chire na sa soon as about when it comes to the evidential burden of proof it is like it's also a tactical because evidence no ubetimi akura pa so ye nyintu esan say woni ema e wo say we ye ma wo evidence ye edim na wo krata edim enti wo say here party is to produce evidence that is to support an assertion. Say was a woman evidence e be boa wasem ana say e be bre nipa na woni na etwe manso na e be bre ono na sem ayede ase e hono no state the controversial case of Akufo-Addo Bawumia in Obechebelamte versus Mahomet Electoral Commission kai special edition case state e no wa ha ti ori e no say let me state that the plaintiff should have attempted to certify o say nka wo say wo mutu anamon say wo mu certify kratana to anamon say wo certify kratana to anamon say wo certify kratana na mpo fa letter na wo de akoma embassy no Ghana embassy we Germany no fa say no ka ho say ye tu sa anamon no enu mpo ka be kire bibi yenso ni nyina no anye dey amanisa yento aso ma fa ba yento aso o say authentication as ma ya kan o say authentication no amaso a any certification no amaso a okay na mom na was a lawyer no for AKOSUA SERWAA no na was what the original certificate no back court because what can say e wo ho. See the court was informed. I'm not making Mrs. Mameka, I'm not making. See the court was informed that there was an original certificate. However, what was brought to the court was an extract from a family book. Into no original certificate na court need that to sell mo de baba no. Name extract and I say copy bia e koyi free family book German for a family book mo no. E ho na omo de buy. Name eno so no. A lawyer for AKOSUA SERWAA editu mu e wo open court say extract name and your original certificate. The document therefore could not be the original and its copy being exhibit B. Nti exhibits no mo de buy no. But say ne say nti sa extract no na ono ontimi consider ne say your original copy and no de nyina ye ne ya adwe san say extract is extract, original copy is original copy. Nti we no say therefore the extract cannot be a proof of a civil marriage. Ne say nti extract na am the free family book no enti me nya evidence supporting a civil marriage between Mami AKOSUA SERWAA any that lumba. Into the extras is significantly different from the evidence. No much work also say and no more they buy a marriage certificate. Two different things. The santi court no intimi engine. Now we no it was the same patch you will pay 29 sorry. You will pay 39. Into Hanover no say Nessa so and extra a free a foreign document a foreign signature said you would can specifically no evidence act no section 161 no ama conditions be a was away they would so into when this wa me Emma yenje krata no foreign krata nentum e ho no about the case of Hussein versus Eba Supra na ODO BRONI lawyer no aboso o say team so say sene omukura was a case ni o kura ni saa e wa asem yesuso emu nti e ho no mo no o ka say exhibit B na wo mo de ba ye no e wo se nkenya authentication no any the civil marriage certification ni nyina e free Bonham marriage registry e wo Germany no esan say mmara no e undertake senka e wo se saade na ye den e baso nti amaso no wo no ontimi nya ho hwe. There is nothing before the court ade bia wo de hwe ni court na nimu e wo se court ni ye den e consider no wie no call ye ma me honesty na fosu so a statement is no so wo ka say na ODO AKOSUA SERWAA ene ye papa da LUMBA e ware wo Germany no wo ho na emum cross examination no omo kusa no cross examination ne say ohun so omo signing was she there when they were signing the marriage certificate? She asserted that I was there. Kase no wo no mo sign emi na pay was it the paragraph 8 of your own witness statement no you claim that the only person where you answer beside your mama Ernestina Fosu who witnessed the marriage was Georgina and not you. That is where the can one witness statement mu say ya mama Georgina na ogina mu ascertain no Emma AKOSUA SERWAA no pe na ehun so mu mi no ware na enyo no nti ade nti na afi de wo ka that is almost 30 punchy holes for witness statement no so there emu no say that be me nua be ma no o say e de me ene Georgina ene call the same day so we were living with them in Germany. That is no o di tu enti no omu busa ne say enti woni me ya adwen say na wonua be ma no ne e ma me AKOSUA SERWAA sign certificate no ono ka say hano na na what you me there is say once they were married they will sign a certificate which means one share there or as you say anyway yeah also hu ya hu ento aso enti Mera Dorinda say answers na e ma me Ernestina ma ye no clear say marriage certificate must have the signatures of the couple because also mummy no sign. And if not, the mere reason for an expert witness should have been brought by the plaintiff. Or say mummy no a signature ni ehun expert witness na sem ne dey. Ko say amutimi at least omutimi ye dey. E dey ba. O say nke be speaking to the prominent features of a valid marriage certificate. As I say, enti no o say munhwe. O say then a look at exhibit 0 series is supposed to be that the LUMBA and the plaintiff signing a document. It can be any document. It could be okay, or say signing a document. Or say if the evidence is true, then a marriage certificate bearing the signatures of the parties should have been submitted. See some of the picture about wumi no sign criteria be there. Any anka was a certificate no. You must wumi no omu signature yeden. E was so. San work on. Nti eno no. Who say wumi no signature ni so. Signature na was so ni German official bi so ono so one ye dey want tiasi. Sa na ma ni nyina. So see in the alternative, the absence of such signatures on the marriage certificate from Germany should have been affirmed by the expert witness. But since mudia mu signature no was okranka mama me expert witness. Mama me no subi. So we no se Ghana aware krata no. Ube hu signatures of the couple. Wa ware wo mbre mu abe hu se wo be sign. Ura be sign and now yere be sign. If the court is presuming German law to be the same as Ghana law, then it's a court na ifa Ghana German mrate said ye Ghana mrade. And en ko say ye hu omumi no omu signature also so what I say but ni nyina no ni omu de ba ye no ye hu bibia sa explanation bia so nim enti it is more the reason that the document should have been authenticated because me no certificate ni so enti no kura sa na emere nyina enti no cause at least munya authentication kakra na mutibi de boa ye and the signature identified and certified as required by government. It's still our Odasujina certification. No, so page 13 yedri. Odasuka that is authentication as a is serious matter. Into the same document is attached. The same document is seen attached to Exhibit C, being the letter allegedly written from German embassy. The last paragraph, Exhibit C says, attached you find a copy of the said marriage certificate for your perusal. Now, I want to know say, omo de krata bi fi German embassy buy. Say, I don't omo trust I was here. No, sister, krata no omo de buy. It's supposed to be the same document as Exhibit B, but it has a different signature and a date. The document is signed by G. Stans Bemeter, a German date. And now my date, 23rd October 2025. 23rd October 2025. Or say, and not just Exhibit B, no. I supposed marriage certificate, no, so has the signature of another Bertram. And yeah, Bertram Stans beat him. Hey, do you know the Biamtino said dated 12 August 2025. Or see, the two documents look similar with similar information, but there is no explanation as to why a different signature needed. Honey, dear, she told me, say, Judge, no, confusing. See, you say the court has not been given any explanation as to why Exhibit B, is seen. Or say, is at the current Exhibit B, and Exhibit C, no, so because as to what exactly which one was brought as the original or said to be an extract, even if it is the marriage certificate, same cannot be relied on by the court as they were not authenticated. And now omunina also contrary to section 136 and 161 na ya boss me that's I say more.